Okay, here's the deal. In a few days, the United States Supreme Court is going to hear one of the most significant birthright citizenship cases it has ever heard. And how that case is interpreted will affect whether children born in America to illegal alien parents are US citizens at birth or not. So in today's episode, let's fully examine the issue of birthright citizenship. What is it? Where does it come from? And what does this potential ruling mean for its future? I'm Jake the Lawyer, and welcome back to Internet Esquire. All right, so this whole situation stems from Executive Order 14160, which was signed by President Trump in January of 2025 and is otherwise known as the Protecting the Meaning and Value of American Citizenship Order. The core purpose of the order is for the executive branch to interpret the 14th Amendment's Citizenship Clause more narrowly, thus creating two new scenarios where children born in the United States are no longer citizens at birth if they are children born to illegal alien mothers and the father is neither a US citizen or a lawful permanent resident, or they are children born to alien mothers on temporary visas and the father is neither a US citizen or lawful permanent resident. Now, a quick note here, I'm going to use the term alien throughout this video because that's actually the correct legal term that's used in the Immigration Code. All persons who are not US citizens or nationals of the United States are otherwise known as aliens, and whether or not they are illegal or legal depends on their right to remain in the country. And if you're interested in more on the Immigration Code, I did an entire video called Lawyer Explains ICE and our entire immigration system, which you can see with a link in the description below. Check it out. Anyways, moving on. Aliens. The key provision of the Citizenship Clause upon which the order rests is whether children would be subject to the jurisdiction of the United States upon birth. So to understand that, let's take a look at the legal history of where this idea comes from. The fundamental concept of birthright citizenship is very simple. If you are born here, you are an American citizen. It's really as simple as that, and the authority for this arises out of Article 1, Section 8, Clause 4 of the United States Constitution, which says that Congress shall have the power to establish a uniform rule of naturalization. Now, for the first 80 years or so of the country, this didn't really have an exact definition. It wasn't until we get the 14th Amendment in July of 1868 where we actually begin to attach a more thorough definition to what it means to be an American citizen. Written as a way to guarantee the legal and civil rights of freed blacks in wake of the Civil War, the 14th Amendment's Citizenship Clause is the very first line of the very first section of the amendment. It says, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. This clause was then written down and codified in 8 U.S. Code Section 1401, and this is what that says. The following shall be nationals and citizens of the United States at birth. A person born in the United States and subject to the jurisdiction thereof. This is the modern law as it applies to birthright citizenships as it came out of Congress in the Immigration and Naturalization Act. I got it wrong. It's the Immigration and Nationality Act. Forgive me, all you sticklers out there. Is it nationality? Is it naturalization? Who knows? It's nationality. Does it matter? No. Anyway, that's the thing that established the INA. And now it's part of the Department of Homeland Security. Anyway, I have a whole video on that too. All right, so while there are well-recognized exceptions to this that we will discuss in a moment, this is the core of where the modern idea of birthright citizenship comes from. And under Article 2, Section 3, it is the job of the executive branch, and therefore the president, to take care that the laws be faithfully executed. As a general idea, this means that the executive branch of government is responsible for reading, implementing, interpreting, and enforcing laws passed by Congress. And this isn't just true for citizenship law, this is true for all of American law. This is how the branches of government function and work together. Now, sometimes the president, in conjunction typically with the attorney general, will issue authoritative interpretations on the laws passed by Congress so that all the other departments of the executive have the same understanding and way in which they are applying and interpreting and processing the law. And one way they do this is through executive orders. Now, here's the thing about executive orders. They hold the force of law on existing constitutional and statutory powers, but they cannot create new laws, they cannot overturn Supreme Court decisions, and they cannot appropriate new funds. And most importantly, they can be declared unconstitutional by federal courts and by the Supreme Court. So if an order is viewed as going too far, then people can step in who are affected by that order and effectively sue the government, saying that it is a violation of the Constitution. And that is exactly what's happening here with Executive Order 14160. So knowing this, we have an executive order which directs the executive branch to interpret the Citizenship Clause of the 14th Amendment to not apply to children who are born to illegal alien parents or parents on temporary visas. Now, at a glance, that seems like an incredibly narrow interpretation, and that's because it is. Now, that doesn't mean it's wrong or that we have to get all emotional about it because we're talking about children, but it is an incredibly narrow interpretation historically when you apply it against the backdrop of the law that it comes out of. And the entire theory of that interpretation being legitimate is riding on the second part of the sentence, subject to the jurisdiction thereof. So what does this language mean historically? Does it have some special meaning? Yes, it does. It's actually very old. It's about 400 years old, this idea. In fact, it's probably even older, and it was just simply recognized about 400 years ago. Like many things in American law, it is rooted deeply in English common law principles. And the classic source of the "if you were born here, you're a citizen" idea was first recognized in an English case called Calvin's case, which took place in 1608. Ah, yes, you must remember Calvin, dear Calvin, from 400 years ago? Yes. No, for real though, Calvin's case established that a child born in Scotland after the unification of the Scottish and English crowns under King James was considered under the common law to be an English subject and therefore entitled to the benefits of English law. And the overarching natural law root of this entire idea is based in the concept of allegiance. It's really this simple. If you were born under the king's dominion, you were born under his protection. And since you were born under his protection, you owe him a duty of allegiance in return. I know, sovereign citizens, you guys would not have thrived in Renaissance and Reformation England. I'm sorry, it's just the way that it is. Haven't you seen Braveheart?
Never in my whole life did I swear allegiance to him.
It matters not. He is your king.
That's basically what it is. Anyway, this idea was then picked up and summarized by 18th century English jurists, including the famous Sir William Blackstone in his Commentaries on the Laws of England of 1765, which became one of the best known descriptions of English common law and was often cited in American law, especially early American law, as a source of where things come from and how they should be interpreted. Okay, but it takes it a step further in a way that we often don't think about today. Natural allegiance was also viewed as a perpetual debt of gratitude, which could not be forfeited, canceled, or altered. And there were specific exceptions, very clearly delineated specific exceptions even back then for specific types of people. The clearest exception was for children born to ambassadors and diplomats while they were in a foreign country. Those children were still considered to be English subjects, even if they were born, say, in France or in Spain or somewhere else. The next clearest exception was for children who were born to enemy occupiers of English land, as in an enemy army came in, they took over an area, we don't want them there, and they had children while they were there. Those kids are not English subjects. But there is one specific line in Blackstone's commentaries that I think perfectly represents the idea as it came out of English common law and we took it on and applied it to American law later on. The children of aliens born here in England are, generally speaking, natural-born subjects and entitled to all the privileges of such. So knowing that, what exceptions are there in American law and, say, American case law precedent that would give credence to the idea that a child born on US soil is not a US citizen if both of their parents are illegal aliens or on temporary alien visas? I thought you'd never ask. I am dying to tell you about US case law and legal precedent. Actually, before we begin this segment, can I just go on a quick rant about the 14th Amendment, please? It is one of the most poorly written amendments that has ever been ratified, and as a result, it has created some of the most overbearing interpretations of federal law ever. I'm going to do a whole video about it soon, and the only reason why I haven't done a video about it yet is because I've been unable to find an expanse of time vast enough to simply write down all the things that are wrong with it. That's how much it changed American law. Not kidding. Anyways, Rant over, let's move on. US case law. The Supreme Court's earliest big discussions on the Citizenship Clause of the 14th Amendment came with the slaughterhouse cases of 1873, and they found as follows. The phrase subject to the jurisdiction was intended to exclude from its operation children of ministers, consuls, and citizens or subjects of foreign states born within the United States. That definitely sounds a bit more narrow than the old Blackstone's commentaries of common law, doesn't it? And that's because it is, but the problem with the slaughterhouse cases is that it wasn't dealing with the Citizenship Clause directly. It was dealing mostly with the Privileges or Immunities Clause. So while we do have some precedent which gives credit to the idea of a more narrow interpretation, that case itself doesn't squarely land on all fours before the law, and it ends up not being as important as one case that we're about to talk about. The next case is that of Elk versus Wilkins in 1884. This is one of the few Supreme Court cases that actually drilled into the phrase subject to the jurisdiction specifically. The court said that the words do not mean merely subject in some respect or degree to US law. Instead, they mean being completely subject to the US political jurisdiction and owing them direct and immediate allegiance. Based on that idea, the court found that the man named John Elk was not a US citizen at birth because he was born on tribal Indian lands, and therefore his primary allegiance was to the tribe first and foremost, and not first and foremost to the United States. And while the US Code was later amended to change this under the Indian Citizenship Act of 1924, that's the way that the law was at the time. If you were born on tribal lands, you were not automatically a US citizen. Now, where that matters for the purposes of our story is that Elk versus Wilkins did establish real precedent that shows the words subject to the jurisdiction have real exclusionary force. But again, like the slaughterhouse cases, it's not perfect. In the case of Elk versus Wilkins, you're dealing with an American Indian, which is not the ordinary circumstances that you're talking about when you're referring to aliens and illegal aliens. And then came the mothership case of all birthright citizenship cases, the case of United States versus Wong Kim Ark in 1898. A man named Wong Kim Ark was born in San Francisco in 1873 to parents who were subjects of the Emperor of China. But having been born in San Francisco and being a California resident his entire life, he went to go see his parents in China in 1895, and when he tried to get back into the country, he was denied entry on the grounds that he wasn't a citizen. And this case became the primary case of how we have interpreted birthright citizenship ever since. So when Ark gets back and he's denied citizenship and entry into the United States where he was born and where he is from, he's like, what the heck, guys? I'm a native-born US citizen. And the Supreme Court held as follows. A child born in the United States of parents of Chinese descent who at the time of his birth are subjects of the Emperor of China but have permanent domicile and residence in the United States and are there carrying on business and are not employed in any diplomatic or official capacity under the Emperor of China becomes at the time of his birth a citizen of the United States by virtue of the first clause of the 14th Amendment. And it is this case that is the controlling precedent which Executive Order 14160 will have to overcome in its argument. And it's easy to see why this is. The original court opinion of the case of Wong Kim Ark is something like 84 pages long, and it spends about 50 of those pages digging deep into the history of birthright citizenship, going all the way back to those old English cases we were talking about. So the ruling is dense after 84 pages of analysis, but I found the best summary to be this. The 14th Amendment affirms the ancient and fundamental rule of citizenship by birth within the territory, in the allegiance and under the protection of the country, including all children born of resident aliens, with exceptions or qualifications, as old as the rule itself, of children of foreign sovereigns or their ministers, or born on foreign public ships, or of enemies within and during a hostile occupation of part of our territory, and with the single additional exception of children of members of the Indian tribes owing direct allegiance to the several tribes. So at the time, that was the only additional exception that the United States added to the 400-year history of the common law. So that is the history of how we got here. And from this history and precedent, it's pretty clear that the law leans in the direction of giving citizenship to anyone born here, with some limited exceptions. So if we take all of this understanding, US case law, English common law history, and we apply it to Executive Order 14160, where do we stand? Well, first and foremost, if we look at the text of the actual order itself, it correctly states that the source of its authority is the 14th Amendment. But then it states this: the 14th Amendment has never been interpreted to extend citizenship universally to everyone born in the United States. The 14th Amendment has always excluded birthright citizenship from persons who were born in the United States, but not subject to the jurisdiction thereof. And this is the core legal issue that the Supreme Court will have to decide on April 1st in the case of Trump versus Barbara. It all just depends on how the court will view this narrow interpretation of the Citizenship Clause. Will they see a more narrow interpretation as constitutional, or will they stick to the more traditional, broad interpretation we've seen since the case of Ark in 1898? Either way, I think that the evidence for broad interpretation, given what we've learned from English common law and then supported by the case of Wong Kim Ark, is the most likely outcome for the court's ruling. It has sound case law, well examined, and it is consistent with over 400 years of common law precedent. But the argument for the more narrow interpretation isn't entirely unfounded. The truth of the matter is that the Supreme Court has never actually specifically decided whether a child born to illegal alien parents is a U.S. citizen if they're born on U.S. soil. And again, the difference between that and the case of Ark was that Ark was born here to parents who were lawfully permanent residents. They didn't have lawful permanent residence back then, but they were lawful and they were permanent, and he was born under those conditions. His parents weren't tourists, and they weren't students on temporary visas, and they definitely weren't illegal aliens. So if this matters, then the question of where the child's primary allegiance lies becomes the underlying question the court must answer. Now, if the order is found to be unconstitutional, then things will largely continue as is with a more broad interpretation of the Citizenship Clause. However, if the court finds that the order is constitutional, then there will be a few dramatic effects. First, and obviously, if it's constitutional, a lot more children born on U.S. soil will no longer be considered U.S. citizens at birth. And again, while this is not something that doesn't happen, it's just specifically limited to some very well-established exceptions. It would also immediately change in practical terms how documentation and recognition of citizenship works currently. A U.S. birth certificate would no longer be sufficient to establish U.S. citizenship. Citizenship would now require proof of parental citizenship or immigration status, and would deny citizenship unless such proof is provided. And any child born under this new interpretation would be considered to have their parents' nationality, thereby adding a new class of people to the list of exceptions not subject to the jurisdiction of the United States. Finding the order to be constitutional would also change what the idea of allegiance means as it comes out of English common law and applies in our law today. The concept of who you owe your allegiance to is typically not something that's tied to your parents, but is tied to you, depending on where you are born. Traditionally, this doesn't have almost anything to do with your parents unless they happen to be foreign diplomats or enemy occupiers. So a ruling in favor expands upon the idea that your allegiance at birth is now more heavily influenced by who your parents are than specifically where you were born. And it's not that we don't already have this concept of jus sanguineus or by the right of blood in the United States currently. We do have this. It's very simple. If you were born to American citizens, even if you weren't born on American soil, you're still an American citizen. But if the order is found to be constitutional, we will be expanding the influence of who you were born to. Not saying that's necessarily bad, but that will set a precedent of that influence going forward. And lastly, the thing that the court will have to also consider here is the authority of an executive order itself. The president, any president, does not have a free-floating ability to establish new classes of citizenship. Congress has the Article 1 naturalization power, and the existing citizenship at birth laws are written down and passed by act of Congress. And while yes, the executive branch must administer, enforce, and interpret that law, it cannot rewrite the law by virtue of its interpretation. And on top of that, given that this interpretation is coming entirely from an executive order, we would effectively be allowing an executive branch guidance order to essentially rewrite how birthright citizenship has been applied and interpreted for well over a century. Now, I'm not going to say that that's impossible or that that's somehow a miscarriage of justice if the court finds that way, but it certainly does push the authority of what executive orders are intended for and capable of to its absolute outside maximum. And here's the other risk that the Supreme Court runs if it finds in favor of the order. Typically, executive orders are exactly that. They're an order issued by the president. That means that later presidents can come along and remove them or amend them or make other orders which have different interpretations of the law. However, if the Supreme Court rules on the constitutionality of an interpretation, later presidents cannot come along and change what was ruled on. And because of that, it has this effect of sort of circumventing congressional action and replacing it with an executive order and then not allowing it to be changed ever again without an amendment to the Constitution. So if we can abstract this for a moment from the citizenship issue and we start to look at it across the board at how this could potentially apply to other issues like guns or abortion or any other hot button issue, you start to see how this isn't really the direction that we should probably be going with our legal precedent. It's this continuation of the transfer of authority from what should be in the hands of Congress into the hands of the executive. And in my opinion, we've already been doing that way too much over the last 100 years. It's like we got income tax and then boom, everything became the job of the president. Anyway, at the end of the day, I don't think it's likely that the Supreme Court will rule in favor of the order. Not that it's impossible, but just that them ruling against it is more likely than not. The long-standing common law interpretations, plus the very square interpretation we got out of the Ark case in 1898, don't really feel like they lean into a dramatic reinterpretation being necessary here. The bottom line at the end of the day is very simple. With few exceptions, if you are born here on American soil, you are subject to the jurisdiction of the United States, and that makes you a citizen of the United States at the time you are born. That's the law. That's been the law, and yes, this law could change, but I think it's more likely that it won't. Anyway, that's it. That's the video. I hope you learned something. If you have other ideas for new videos, let me know in the comments. I'm in there every video talking to people. It's a great time. If you've seen more than one of these, definitely consider subscribing. And other than that, I just hope you have a great day. We'll see how this goes. Okay, see you later.